Before you restart, Mr. Elkington, can I just mention a couple of small matters? There is, I think, I seem to remember authorising a transcript. We will presumably get copies at the end of the day in the usual way. Right, just wanted to check that. Secondly, my clerks had a communication from a legal journalist who is watching the case remotely in the United States, and said she had asked for and not yet received copies of the skeleton arguments. I can't believe there is an objection. I don't make a direction. I haven't checked, had a chance to check whether it's formally within 33C, but I suspect it's certainly within the spirit of it. So could that be attended to unless there is some real objection?
Yes, indeed. In practical terms, should we contact my Lord's clerk and to send them on, and they can...
Oh, as regards the the skeletons. No, that, well,
how do we know?
I think the way... I haven't had an opportunity to research all this. The way, of course, it works with an old-fashioned hearing is the journalist here and they're given a paper copy. But I think with remote hearings, I think there was an informal practice whereby they were simply emailed, or for all I... This technically isn't a remote hearing, so I don't want to get down into the weeds.
No, I'm just saying
but I gather the person in question has been in touch with the solicitors.
Oh, that's fine then. I was just saying, otherwise, we just need the email address.
Yeah, oh, I see, yes. Yeah. No, I'd say no more about it, but a nudge.
Good, thank you. Thank you. My Lord, can I correct one thing which I think I said this morning, and the transcript will no doubt reveal. I said it's common ground that aggregation needs to look at from the point of view of the insured, which it is. I think I also said that it's always been common ground that the issue of whether or not something is an accidental injury falls to be assessed from the point of view of the insured. That's certainly the case now. There was a time when Spire was taking the point.
Yes, we spotted that.
Yes. I think that was...
I don't think you did actually say that, because I would have picked you up on it if you had.
Good. Well, I'm afraid I didn't have the confidence to say, no, I didn't say that, but perhaps I should have done. Anyway, good. Let me turn then, please, to, if I may, paragraph 80 of the particulars of claim, in the core bundle behind tab 9.
Sorry. Yep.
Paragraph 80 on page 108.
Yes.
And this is where this is the guts of Spire's case. That is entitled to £10 million per group. And I just wanted to make some 6 points about this, if I may, with the introductory observation that, as you know from the cases, what the court is meant to be doing is looking for a unifying factor, rather than, as the judge did, looking for differences. If you found a unifying factor, you shouldn't go on further to look for differences between the cases if there's a unifying factor between them. And this is in the context here where...
Well, that may be oversimple, I think. Of course you've got to look for a unifying factor, but you can't just pluck anything they have in common and say, oh, well, that's enough, if he's overwhelmed by differences. I think it's not quite as neat as you're suggesting.
I'm not going to disagree with that, my lord. The second observation is, as we've seen from this morning, so far as Spire's liability to the patients was concerned, and so far as Spire's entitled to an indemnity is concerned, that's the same across the two groups. And so it's instinctively a bit odd that when one then comes to the stage of aggregation, you should draw a difference between those claims.
Yeah.
So the first of my points...
Oh, sorry, I thought that was the first of your points.
It's part of the preamble.
Right.
Preamble.
Right.
Is just the observation that in relation to what is called the first group, it is said in the last sentence, the one source or original cause is Mr. Patterson's negligent conduct of breast surgery. So it's Spire accepts that where you have hundreds and hundreds of operations by Mr. Patterson on various patients, those operations all have the same source. And one asks rhetorically, what is that source? My submission, that source is Mr. Patterson. And they also accept that those hundreds and hundreds of different operations on different patients over a number of years have the same cause. And again, in our submission, that cause is the fact that the poor patient had the misfortune to be treated by Mr. Patterson at Spire Hospital. Mr. Patterson was a rogue surgeon. So we already have an acceptance that hundreds of claims aggregate. The second point is in effect, exactly the same point in relation to the second group, where Spire accepts these hundreds and hundreds of operations on hundreds of patients have the same source and original cause, albeit here they say it's Mr. Patterson's deliberate dishonest conduct of surgery, which wasn't clinically indicated. Again, when asked what is the source, submission that's Mr. Patterson, and what's the cause of the claims against Spire? The cause of the claims against Spire, again, the poor patient having the misfortune to be treated by the rogue surgeon. The next point is to say it's wrong to say that the claims are not consequent or attributable to the same source or cause if Mr. Patterson's conduct can be labelled as negligent for some and dishonest for others. His motivation is irrelevant. I think that's clear. And one thinks when a patient comes to plead a claim, you wouldn't plead what the surgeon's motivation was for the misconduct. You just say it was misconduct. In every case, the unifying factor is Mr. Patterson operating on them without their informed consent. The next point is that the distinction that's sought to be drawn between the Group 1 cases and the Group 2 cases is, even if it were relevant, is not a sound distinction. And what's pleaded is that the first groups of claims are consequent or attributable to his negligent conduct of breast surgery. As we've already seen, that was an operation which isn't clinically recognised, and I don't need to take you to the agreed definition of clinical terms. It's in the core bundle, but that makes it clear that if a mastectomy is required, then a subtotal mastectomy is totally inappropriate, and a CSM is a form of subtotal mastectomy. Because in effect, you leave a ticking time bomb in the patient's cancerous cells, and a number of these patients died after their CSM. And we've also seen that within the first group, no distinction is drawn between operations pre and post January 2008, the date when he agreed to stop carrying out the surgery. And the judge found that the conduct in the first group was dishonest. And we can see that in the judgment if we just look at that. Judgment is behind tab 7 of the core bundle. He's dealing with the claimant's group, what they call their group 1, in paragraphs 4 and 5 on page 69. And I invite you to read paragraphs 4 and the start of paragraph 5. And in paragraph 6, it refers to the fact that he was both in the NHS and at Spire, where he agreed not to carry out any more of these procedures, but he carried on carrying them out at both the NHS and Spire.
Yeah.
Then if one sees at paragraph 31, it was submitted by Spire that it was of the essence of the Group 2 cases that they were all the result of dishonest conduct. The patients were lied to concerning the result of diagnostic tests and need for surgery. RSA submitted that the Group 1 cases involved dishonesty as well. So it did, but it was entirely different nature. Dishonesty involved in failing to tell a patient in need of a mastectomy that the surgeon intended to perform STM surgery, or the risks inherent in such surgery, and of performing such surgery having previously agreed with the managers that he would not to do so, is different from the dishonesty involved in the Group 2 cases. So the judge found that there was dishonesty in both cases. Not sure dishonesty really does justice to what was being done here. This wasn't stealing someone's wealth, it was stealing their health. So Group 1 is both negligent and dishonest. Then if we come to Group 2, again, more surgery without the patient's informed consent. And it was accepted in Spire's written opening, and I can just give you the reference unless you want to look at it. It's paragraph 4.836. Said that such conduct was self-evidently negligent and a breach of duty. So the pleading says it's dishonest. It was accepted at trial that it was self-evidently negligent and a breach of duty. So like Group 1, it's both negligent and dishonest. The next point is that some claims...
Point 5, have I numbered them correctly?
Number 5, yes, I'm afraid I've gone horribly wrong with my numbering and I apologise.
No, not necessarily.
Some claims fall into both Group 1 and Group 2. And if I give a specific example, and if we look at Spire's opening in the supplemental bundle, behind tab 10, and the poor patient referred to on page 170 of the bundle. The patient referred to at paragraph 4.61 refers to the initial conduct, and then in the last sentence, in addition, he performed an unnecessary CSM on her right breast on the 15th of May 2006, having lied to her GP about the appearances on mammograms. So that is surgery that doesn't need to be done, and the surgery that is done is an experimental procedure, a CSM.
I mean, the judge's answer to that point was that you could have a claim falling into one of each group, but one in relation to the subsequent negligent surgery, one in relation to the earlier.
One could, but the what is being said is that these groups have different causes or sources, the claims falling in this group. So here we have one operation by one surgeon on one patient at one day, which are said to have different sources or causes.
Yeah. That
That just can't be right. So that's one feature of these cases that straddle both groups, which really shows how the distinction is unsustainable. It's just not right that these different groups of claims have different causes or sources. The second point is This is something referred to, I could take you back to the judgment at paragraph 34, an example the judge gives there. It's not an example, it's a summary.
So this is para 34.
Paragraph 34 on page 79.
Yeah.
Where he says that occasionally a private patient would suffer both a group 1 and a group type of procedure at the hands of Mr. Patterson. An example is another of the lead claimants.
It's the one you just showed us in the pleading.
I don't think it is, because here there's a temporal difference. It's a year later.
It's not the same operation.
That there's the second operation.
Yeah.
Was it the same example?
4.61.
Well, it doesn't matter for present purposes. The point that's worth making is that what we're looking at here is that there will be a claim by this patient against Spire, claiming damages. And Spire will want an indemnity for that liability if it has a liability. And the idea that we could put that claim where the conduct falls into both categories, because on 1 year she had a breast operated on when there was absolutely no need at all. The second year there was a need for an operation, but it was a CSM, so it was done improperly. The global award of damages, if Spire is right, then when it comes to the question of aggregation, you've got to work out how much of that damages falls into Group 1 or Group 2, because it may be that the £10 million limit of indemnity would be exhausted for your Group 1 claims, but there'd still be some remaining in your Group 2 claims, because you only got to 9.5 million or whatever it might be. And so then you would have to divvy up the damages that were recoverable by this claimant, which the trial judge wouldn't have done because there'd be no need to do so. The trial judge would give a global award. And then to work out what indemnity Spire was entitled to, you would need to divvy up that damages somehow without that patient being there. What that illustrates is that the distinctions that sought to be drawn, again, are commercially unworkable when one's looking at the terms of the policy between Spire and RSA. So that's why in our submission the distinction that sought to be drawn in paragraph 80 fundamentally breaks down. And then I wanted to just make some very brief comments on the authorities.
Oh.
There's a fairly arresting statement in Spire's skeleton, which is that if you were to allow this appeal, you've got to depart from or overrule the reasoning in Caudle and Sharp, Cox and Bountside, and the Cultural Foundation. We don't accept that at all. Just taking those cases in turn, Caudle and Sharp involved an event aggregation clause.
Yeah.
It's a much narrower clause. And so what's said about the meaning of that clause doesn't require you to overrule it at all. Cox and Bankside we looked at this morning, and as the court observed, is actually supported because it said that all the claims arising out of the conduct of one underwriter aggregated. Two further points I'd make about the case just for completeness. The clause in question referred to original cause, but didn't have source. And also that case was decided before Axon Field, where the House of Lords made it clear that our type of clause, originating cause or source or cause, requires the widest possible search for a unifying factor. And then the third case, which it said you've got to overrule or not follow, is Cultural Foundation. That wasn't an aggregation case at all. The issue there was about what claims attached to what policy years. And that depended on the scope of the notifications made to those years. And one of the thoroughly bad arguments that was made by one of the parties was, well, look at this aggregation clause, to which the judge said, well, you don't aggregate claims which attach to different policy years. And then he went on to say, and also, you can't do it at such a wide level of abstraction. But it's not an aggregation case at all, which is why it doesn't refer to, for example, AXA and Field or the Lloyd's TSB cases, the aggregation cases. So there'll be no need for you to overrule that. And then the last case, if I could just take you briefly to the Standard Life and ACE decision of Mr. Justice Eder, which is in Authorities Bundle 1 at tab 14. And this is the only case which thus far has really touched on the presence of the word source as well as cause. And if I could just take you to paragraph 259 of the judgment. So 259, clause in the present policy uses the phrase originating cause or source. The choice of the word originating opens up into what Musters words the widest possible search for a unifying factor in the history of the losses, which is sought to aggregate. Furthermore, the words or source as an explicit alternative to cause can only be included to emphasise yet further the intention that the doctrine of proximate cause should not apply, and, this is the second point, and that losses should be traced back to wherever a common origin can reasonably be found. And
do you accept that that is the explanation for the words or source?
yes,
do you
I do.
accept that they are an explicit alternative to cause?
Yes. And that's where I sought to identify this morning the difference between the nature of the words. A source is a person, place, or thing from which something comes. Now, of course, there has to be some causative relevance. We accept that.
Well, more than that.
Yes.
Something can't be a source unless it's a cause.
Yes.
Quite.
Accept that.
Which is why I think
The source is just a metaphor, isn't it?
I think they're synonyms, aren't they, really? It's a single source or original cause. In other words, original cause or single source are one and the same thing, describing the common origin of the.
Well, I'm not going to dwell on that point, which is clearly finding no favour at all. And
I think it's quite subtle. I mean, in one sense, my position is the same as my lady's, that they are synonyms. I think it's arguable that it does have a slightly different flavour to it. It sort of helps you see what kind of cause is relevant. But these are metaphysical points, and I think analysing one against the other is not likely to help you very much.
Well, I'll move on. And whichever it is, Mr. Patterson is the cause or the source and the unifying factor.
Or his behaviour.
Or his behaviour. So, unless there's anything else I can assist you with, just to conclude that here we have two substantial concerns who've agreed a very aggregation wording, and that provides for £10 million worth of cover where there is a unifying factor. It's going to be multiple claims. And where there is a unifying factor, the cover's limited to 10 million, leaving the balance of the 20 million for other claims. what the court has asked is that the unifying factor. The judge didn't carry out that search. Had he done so, he should have found that the clearly was a unifying factor. Mr. Patterson is a conduct. So unless there's anything else, that's all I wanted to.
Not as far as I'm concerned. No, nor my lord nor my lady. Thank you very much. Yes, Mr. Shapiro.
My lord, I've got 5 brief points in reply and also an answer to my lord's question earlier, which was what happened with the claims. The answer is that the first claims, as my lord may have been anticipating, came in against Mr. Patterson, but there were then requests for records made to Spire in the usual way. And then by the time one gets to the end of 2011, when he's been suspended and the problems have been more widely reported in the local Birmingham press.
Sorry, can you speak up a little?
I'm so sorry. The
first claims came in against Mr. Patterson, but later, when it became more publicised, I think is what you were saying.
Yes, then it starts coming in against Spire and Mr. Patterson, whose MDU insurers weren't the insurer element of his cover was paying, but the MDU declined to, and also against Heft, the NHS trust, for the same reason, because some of the patients had been referred over from Heft, and so one gets a shift from the initial letters of claim coming in the normal way with a request for records to the claims being made against all 3. And that's then how the litigation.
Well, thank you. It's just helpful to understand. I don't think it goes to the legal issues, but
no.
Thank you. 5 points you said.
The first one was to adopt and emphasise the point in our pleadings, which was identified by my lady, Lady Andrews, that the distinction we seek to draw is between treatment where there is a clinical indication for treatment and surgery where there is no clinical indication for treatment. And I hope that would explain my earlier answer to my Lord Bean's example, where I suggested that the first 2 instances would be one group of claims and the third would be the second.
In relation to that, how do you answer the point that's been made against you, that there could be no clinical indication for an STM, because whilst the patient had a clinical indication for a mastectomy, the universal view of all breast surgeons is that you have a total mastectomy and there's no justification for one that's subtotal.
Well, in my submission, that's true of any operation which is performed wrongly. In that there's never a justification for performing the wrong operation. But the important distinction is between was the operation that should have been performed required or was no treatment whatsoever required. The second point was to acknowledge my lady's point earlier that I probably did shift position. There was an analogy drawn or an example suggested by the judge at first instance of 5 hand operations and 5 knee operations. And the question was asked, well, would those aggregate? And we developed that example into a carpal tunnel release and then various types of knee operation, and explained that because the mistakes were different, one would get 2 groups of claims. My lady's example earlier about the orthopaedic surgeon just simply being incompetent across 3 different pieces of surgery encourages, obviously, one to consider that it's the problem of the surgeon being negligent and therefore they should all aggregate together. In other words, the example is approaching it from the opposite end as the judge's example did. So if I need to do the shift to the fact that there's either an indication or otherwise for clinical treatment, then I happily make the shift. But I wanted to acknowledge that I was making it and acknowledge the reason why. That brings me to the third point, which is this. In my submission, one has to decide logically, is the question we're asking that it's sufficient for the surgeon and for there to be the surgeon and negligence, for there to be an original cause? Or does one have to ask what is going on? And in my submission, what seems to be happening is that there's a position being postulated of one does not need to go beyond the surgeon and his negligence, but then one ends up having formulations such as in every case the cause was Mr. Patterson operating on the patient without their informed consent, or in every case the cause was Mr. Patterson and his conduct or his behaviour. And in my submission, either one's deciding that it's Mr. Patterson operating negligently, which is sufficient, or if one's looking at what the operations are, logically one goes into the differences as well as the similarities identified by the judge and assesses them overall to see, are the particular types of behaviour, are the two pieces of conduct properly the same? And essentially, for the reasons that the judge gives, although I probably wouldn't have used motivation to the same extent that he did, in my submission, the two groups are properly factually distinct. So, for example, if one just takes three of the differences, in the Group 1 cases, the result of what Mr. Patterson does is an increased risk in the recurrence of cancer. And as my learned friend said, some individuals who had a CSM subsequently died from the tumour recurring. In the Group 2 case, there was never a tumour. So there is no increased risk of cancer at all. In relation to the management issues, my learned friend took your lordships to paragraph 5.61 of our opening submissions. There's no need to turn up paragraph 5.62 at the moment, but that explains that if you are going to look at management failings, one's got two very different management failings. So in relation to the Group 2 cases, the problem was there was no adequate multidisciplinary team in place. The multidisciplinary team consisted essentially of Mr. Patterson and Bethan Lloyd Owen. And so there wasn't proper involvement by the oncologist, which would have identified that there was not a proper indication of either a tumour or a risk of tumour. And so that's the issue there, is not having the right structure in place before the patient is operated on. In relation to the Group 1 claims, the issue there was that the right mechanisms were not in place to allow people to report the problems that they found afterwards. So, for example, patients would come in for shaves following mastectomies. Now that should never happen, because by definition on the mastectomy, one should have removed all the breast tissue. So a shave to remove further breast tissue ought to be an immediate indication that there wasn't a proper mastectomy done. But the culture that had been created around Mr. Patterson, and where previously people had tried to challenge him and failed, allowed him to get away without properly being challenged. And eventually the Group 2 cases were only found because he was suspended because of Group 1. And at that point, there was a proper investigation which uncovered the wrong diagnoses. The final of the three examples I've chosen, but in my submission, His Honour Judge Pelling's analysis is both correct on the facts and correct in its conclusions, is that in the one case, one's got an entirely unrecognised procedure being done. In the other, one's typically got a recognised procedure being done, but where no procedure should be done at all. The final fifth point is this. We're at the moment looking at this in the context of lots and lots, in fact my learned friend emphasised this, lots of different operations. So lots of small claims and whether they should be grouped. The words, though, original cause or original source and cause, are in use widely and well outside the medical negligence market. If one has, in the context, in a different context, a couple or three very high value claims, then the result of aggregating by person could be quite significant. So if one took an example of an engineer's policy and said, for example, suppose there are two bridges which are badly designed and have to be replaced. If one has the same design of bridge in both cases from the same firm, then in my submission, obviously that should aggregate because it's the same original cause as the problem. It's the basic design of the bridge. But suppose one has a situation where one has one lead engineer who designs two bridges, but there happens to be a completely different problem with the second bridge. On the face of it, in my submission, one shouldn't have aggregation just because the lead engineer is the same. If the mistake or error is properly different, then one shouldn't have the two bridges being aggregated. Or if the mistake on the second bridge is in terms of how costly it is to build, because there's some, taking a similar analogy to that considered by Mr. Henshaw, if one had a bridge that was much more expensive to build because it wasn't programmed properly or one hadn't worked out how to bury the columns correctly, again, just because it's the same lead engineer, one shouldn't have aggregation. And one could similarly look at, for example, if one has the obvious place in medical negligence, to return to the medical negligence, is birth and midwifery, where you can end up with extremely valuable claims if something goes wrong because of the nature of having to compensate somebody for damage across their life if they suffer a disability during birth. If one had, for example, a private hospital group who did perform births and had one midwife who made an error across two operations, if the error is the same, then of course that should aggregate. One might then have a separate issue if there's an error which is quite different in the second, where in my submission it shouldn't aggregate, or on the alternative case that I was encouraged to by Milady earlier, if there's a midwife who causes injuries in one, but then assaults the patient during a second instance of birth, those two shouldn't aggregate. And so the fifth submission is really, one has to, in my submission, think where might this lead in other contexts where these words are in use. And the proposal or the principle adopted by the judge at first instance is, in my respectful submission, principled in that it's asking the question why, which Mr. Justice Morrison put forward, and looking for an answer which is, I accept there must be a limit to the detail that one goes into. Of course that must be right. But it's asking for a more substantial answer why than merely Mr. Patterson. And the substance of our position is that if somebody asks, well, what was the cause of all these claims? It's not really giving an answer why to say Mr. Patterson, unless one identifies that Mr. Patterson was in one case treating people wrongly where they needed treatment, but in the second case assaulting them where there was no proper indication of treatment at all. My lords, unless there are any questions from yourselves.
No. Thank you both very much for your succinct and cogent submissions. We will be reserving our decision. Judgments will be circulated in draft to council in due course, so that they can agree the terms of the consequential orders, and if they can't agree, they should submit short written submissions so that we can resolve any disputes at the time of hand down. Also, of course, we're grateful for have our attention drawn to any typographical or other minor factual errors.